Welcome to Probate Weekly. I'm your host, Bill Gross at Bill Gross Probate. We do this every week. I get asked all the time about a dispute. You know, my brother this, my cousin this, in a probate case. I want an attorney to take him to court. And I often say to them, you just don't understand the cost or the enormity of the process. And oftentimes people run to a local attorney or an attorney that does probate filings and administration, not understanding that litigation, particularly in California, is a whole different animal. I'm really lucky. I'm a member of the LA Bar Association as an affiliate. I watched the listserv and I saw a couple attorneys recommend Greg Aslanian from Trust Law Partners as a probate litigation attorney. So I've never been sued by him or involved in a case directly. Actually, we were, it turns out, I think on a case. But anyhow, that said, welcome to Greg from Trust Law Partners.
Hi, Bill. Thanks for having me today.
And just geography, you're based in California. Where is your office located?
We actually have several offices throughout the state. Our primary offices, I would say, are San Mateo, so the Silicon Valley area, and Los Angeles. We also have offices in Santa Barbara, as well as San Diego, and Orange County, actually. Orange County is a recent addition. Newport.
Nice. So all the nice spots throughout California. So let's talk about, you're a litigation specialist in this area of probates and trusts. How did you end up in the litigation side of that? Did you start with probate and trust and move into litigation, or are you a litigator that found this niche?
I'm a litigator that found this niche. I have a litigation defense background, meaning that I used to work for a law firm that insurance companies used to rely upon when their clientele got sued. You know, catastrophic injury cases, big rig accidents, other type of serious automobile accidents. So whenever somebody gets involved and is at fault and they get sued, insurance companies typically hire outside counsel to represent their insureds. And I was one of those attorneys. So litigation is in my blood. And then I eventually transitioned into this area of law and have found it to be very, very interesting.
Interesting is a good word for it. So when people call me with disputes, I try to get a range of how much money is at risk or how much is at dispute and what kind of resources they have. Oftentimes it's something relatively minor, under $100,000. And I tell them, you can get an attorney who's going to write a really good letter for you and hopefully move them off the dime. But if you really throw down the gloves, so to speak, use a hockey analogy, and to go to the mattress, it's going to cost money. In general, how much, if somebody is going to not pay as they go along, but turn to you on a contingency basis, saying I have a dispute and there's real estate involved, there's blah, 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 you're going to look at that. Obviously, you have to vet it based on what you think are the merits and how likely you are to be successful. But there has to be a certain amount of money available for you to take the case on to make business sense. Give me a guideline. How do you make those assessments? Or what do you tell a customer in that case?
Sure. It's somewhat of a case-by-case analysis for us. It depends on what the dispute is, the level of difficulty, and whether or not it makes sense to litigate. Sometimes a dispute could range from, fighting over knickknacks and personal property items to millions and even billions of dollars. And we've seen that entire kind of range of case. But as far as what it's worth for hourly, I would say the dispute should be, at least $500,000, generally speaking, only because of the expense that comes with litigating and getting a matter to trial. Most cases, albeit never make it to trial, but oftentimes even to get to mediation, it's going to cost six figures, practically speaking. Experts eat up a lot in costs, and then you have the amount of time. These things, this area of law differs from many others, for example, personal injury or even employment, because they're so case specific. So having cookie cutter documents is not really a thing in our field. They're all custom cleaned. It's very bespoke to what we do, and each case is very specific in its fact patterns, the types of dispute, and the evidence that you're going to present. So it is very custom to each client, and they're getting a very customized product.
Typically, does business come to you referred directly by a consumer or by a other financial professional, realtor, accountant, or by another attorney?
Uh, all of the above. I would say the most qualified cases, meaning that the ones that are viable, that we could even do something on, generally come from other attorneys who kind of recognize the potential pitfalls that a layperson just off the street, or even a victim, for example, may not recognize. We get calls and we take them and we speak to these nice people all the time, but generally, if it's a call coming from the public, it may involve matters and disputes that are long past the statute of limitations. Mom or dad passed away in 2005, and I was supposed to get, the house, but my brother took it, for example. And it's been, a decade since that took place, and trying to claw that back is not going to be a successful effort.
Now, not only is it about statute of limitations, but I imagine the facts of the case as well as the dollar amount that's being argued over has to be significant enough to warrant it, right? People call me, somebody's entitled to $100,000. It's unfortunate, but you really can't litigate. You can object, you can file forms and letters, but when you actually talk about taking it all the way through litigation, at some point, it's going to cost you more than you're going to get back if you pay for it.
Yeah, I agree with that. Totally. It's we're fortunate in a sense that we live in the state where real estate prices keep the economy and the value of these cases buoyed. Even in the outskirts of habitation and the habitable areas, real estate, even in those areas, are worth hundreds of thousands of dollars. And you could have a few parcels of land, even if they're undeveloped, that might be worth something significant. But usually single family residence, things of that sort, you're topping, you're bottoming out at $1 million, no matter almost where you are in the state. So yes, you're correct.
Yeah, that's what it's getting to these days. So in getting business from other attorneys, obviously you're fairly well known. I mean, based on what I've seen, do you still actively do things to develop business? I appreciate you're on my podcast today. Is this a regular part of your business, doing business development? Are you pretty much just more about intaking referrals? How does your business look today as a business development?
We absolutely do business development type activities, meeting with folks like you, getting the word out. People really don't realize that our cases oftentimes, whether it's an attorney, a realtor, an agent, or some other type of professional or a layperson, our cases are usually staring them in the face. They've heard everybody's been touched by a circumstance or situation that we could probably help them with. It's just they don't recognize that the claims exist or are there unless they're so flagrant and obvious in their nature that it screams to them that, you should really do something about this. But I'll give you an example right now. I'm handling a case where the decedent, the person who passed away, was divorced from his ex-wife back in the early 80s. But they continue to hold title to a specific piece of property as joint tenants. And which means that, the survivor between them takes it. However, it's not that clear cut because there was a divorce judgment in the case, although it didn't identify that property and say what's to happen with it or how it's supposed to be divided. The estate of the decedent still has a claim. And our efforts are going to be to try to claw back half of it now because it was our client's separate property. The other side doesn't see it that way, but the law is on our side. And we're talking about, I think it's a fourplex, a 4-unit apartment building. So again, a couple of $1 million.
What are the 2 or 3 most common fact patterns of cases that you've been successful with litigating? Are there common ones or is each one different?
There's a through line. There's a similarity between the cases, and I'll tell you what they are. Our primary causes of action in this area, and cause of action for people who are unfamiliar with that term, is just the claims you're suing on. There's a handful that we exercise in what we specifically do. You might have heard of them: undue influence, lack of capacity, and then financial elder abuse. Okay, those are the big three, I would say, in this area. There's others that can be tacked on that are relevant and even substantial in the weight they carry and the damages they come with. But undue influence, lack of capacity, and financial elder abuse are the big ones. They're somewhat intertwined, and generally speaking, most situations call for all three. Sometimes not, but most of the time, I would say all three apply if they apply at all. But yes, those are the ones. And undue influence is, the decedent, the person who created the will or the trust, their free will was broken, and they made a modification to the document, or they created a document that they would not have otherwise done, but for that influence that's exerted upon that person. Usually, the fact pattern we see: elderly set of parents, or an elderly individual, if it's not just one person, who's going through all kinds of medical issues, or failing health, or declining cognitive ability. And then you have a child, an outsider, a caregiver, a new spouse, the Anna Nicole Smith situation, come swoop in and have a document executed by this person, giving them either the lion's share or everything, cutting out the people, oftentimes the children of the person who is passed away, and getting everything. So we see that a lot.
Yeah, I would say as a real estate agent, I see that pattern also from the other side.
Yeah.
So let's talk about undue influence. On one hand, the most caring, giving, remaining child in the house who's, been with mom or dad for the last 10 years of their life, in their mind, they're entitled to everything because they've done that. And the other siblings by default are going to assume whatever's done was untoward. And unless, I'm there to watch and talk to the decedent, how would you really know the difference between the undue influence? What are the common kind of signs or characteristics of undue influence? Now, one obvious answer could be, well, if they just did anything in the last 30 days of their life or last 90 days of their life. But at the same time, you can imagine a scenario where there's somebody who regrets their life and wants to make a change in the last 30 days. So what are the characteristics or what are the signs that it's crossed the line to be undue influence as opposed to influence?
Sure. We're wary of even a little bit of influence. The things I typically look for, how did the document come to be prepared? Because the moment pen hits paper and that document is executed is the relevant time period. What condition was the person who signed that document in? What were the circumstances of its creation? Who contacted the attorney, or sometimes it's not an attorney that prepares these documents? Who contacted them? Who conveyed the terms of the trust or the will to that person, the person who created the document? How involved were they? How medically frail was the person who signed the document? In situations like that. So, the vulnerability of the victim becomes a factor. Whether or not the decedent, the person who passed away and created the document, and the undue influencer had a confidential relationship. Did the decedent trust that person? Are we talking about a child where it's kind of a natural relationship, or is it some caretaker, a neighbor, some other outsider, a friend? And the level of participation, if they were actively participating in the creation of the document, and then the equity of the result, it's called, meaning that how fair is the result? Is it unnatural? Cutting the kids out and giving it to a friend that they haven't seen in 20 years, or an ex-girlfriend that's been out of the picture for half a decade. Is that normal? Obviously you'd argue not, but it depends. And then you have to assess the evidence. The difficulty of litigating these types of cases is the one and only person who can really kind of tell you what's what is no longer around. So you're piecing the case together. It's an investigation. That's what makes practicing in this area very interesting and stimulating for somebody like me. It's you're trying to pull a Columbo move and one more thing, right? Like, and just bust out that piece of evidence that you hope you can find. Sometimes, these bad guys, I'll call them, do such a good job of hiding their tracks or doing things in such a way where they get the benefit of the doubt as to whether or not what they did is, crosses the line or not. Sometimes that's not a clear line.
But I would think even a case where, let's say it's one child, and this trust appears out of nowhere that eliminates the other two children, and it was created, 2 weeks before death. It was done at a local, online and notarized by a local place down the street. It was obvious. It was all kind of put together. That son's going to say, "Hey, Dad wanted me to have everything because I took care of him. The other kids abandoned him," and make his case. I would imagine as a litigator, you still have to prove that case. I mean, you can't just walk in and say, "Hey, it's the son. He wrote the other people. He obviously created the document. He didn't let the other kids talk to him." The judge doesn't go, "Oh, well, you must be right. I agree. We'll invalidate the trust." You get paid money, I believe, to make that case in a format, in a process, in a procedure that the judge has the ability to overturn those documents. Is that a fair assessment?
I would say so. I think that's fair. It's not so clear cut. It's never so clear cut. We, as a result of what I mentioned earlier, where we don't have much direct evidence, circumstantial evidence is allowed to come in, witness statements and things like that. That's really what you have to rely upon, but you still got to prove up your case. So what happens is one of the interesting wrinkles of this area of law is that if you can prove a handful of things in a case, so let me take a step back for a moment. The plaintiff, the person bringing a lawsuit, always has the burden of proof in civil cases. I mean, that's the case across the board, I think, even in criminal, but I don't practice criminal, so I'll let that be. But we have the burden of proof. But what happens is if you are able to demonstrate the, kind of the basic facts of undue influence, the burden can shift on the other side to prove that there was not undue influence. Not an easy thing to do. And what I've been told by many a judge and retired judge is that judges don't like shifting the burden, it's called, because it could go up on appeal, and judges don't like, when their decisions and orders are appealed. But it is something courts are able to do and shift the burden, and then it becomes the responsibility of the person who's being sued to rebut that presumption and prove that there was no undue influence there.
But to get there, you have to get to that point. Meaning you don't,
correct.
Yeah, and that's why you have to pick the right attorney to get to the point, because it's not automatic. It doesn't matter how clear the facts are. You still got to put it on paper in the right format, get to the judge in the right way.
Yeah.
And get the judge's attention, I think, is one way the way I kind of think about it.
Absolutely. And look, it's, if you have a lawsuit on your hands involving this area of law, you want somebody who knows what they're doing. And the reason being is they could spot things a mile away or know what to look for or know how to look for certain things, where somebody who's not familiar with this area of law, not familiar with the courts as it relates to trust and probate work, the counties, there's a lot of pitfalls for people who try to go it alone or hire somebody who's just, a lawyer off the street or does everything and dabbles in this.
So the second area you mentioned was capacity. And as a real estate agent, that's an area that comes up to us as well, because the same people who might get a trust done or a will may want to just sell property, list it for sale, get a contract sold. And the question is, what kind of capacity did the customer have? So I guess and I can imagine as an attorney, there are times that you want to invalidate transactions done based on capacity. You want to validate a trust, or you want to validate a sale, saying there's undue influence, or in this case, they didn't have the capacity to make those decisions. What are signs that somebody doesn't have capacity that you would say, as a real estate agent, I should be alerted to as being a defining point? Meaning, it's not our job to determine it, but it's our job to be aware of it and get proper guidance.
Sure. There's a couple of standards that apply to capacity when it comes to this area of law. but I'll go with the lower one. I'll explain the lower one because it's a lot easier to digest, and that seems to be the standard that's applied across the board, even when the higher standard should be the one that's applied. But it's called testamentary capacity. So does the person who's making the decision know what their property is, know what their familial relations are, and understand the consequences of their actions? It's a very low bar, and it's very easy to meet. Oftentimes, even people who have dementia and things like that could satisfy those requirements. That's the standard that applies to wills, simple wills, and simple trust, like an amendment, for example, to a trust that only changes, let's say, a percentage or an amount of a gift instead of it, completely being restated or restructured. But there is a higher standard called contractual capacity that applies to trusts. That's, a higher threshold. But again, like I said, courts have been very lax when it comes to capacity. There's been some decisions handed down in the last handful of cases that really kind of bottoms out that claim. I mean, it's got to pass the smell test, Bill. You see a person, they're clearly not appreciating or understanding what they're doing. You see somebody kind of hovering over them saying, "Oh yeah, mom or dad, sign there," and they're like confused about what's going on. You got to trust your gut. I mean, that's the first thing when you're dealing with a person while they're still alive. Now, I deal with them 9 times out of 10, 9.5 times out of 10 when they're passed. So I'm looking at medical records, medical records from hospitals, primary care physicians, everything in between. And, you'll see on there alert and oriented, as the person, place, time, and or sometimes you see Alzheimer's on there, you see dementia. That's already a big red flag. You look at their medication lists, see what type of medications they were taking, and how it could potentially affect their ability to understand what they're doing. So you kind of have to become a half a doctor, or at the very minimum, have an understanding of what to look for. And at this point, I've interacted with so many experts, medical experts in that field whose job is to assess and then testify as to a person's mental capacity, that what the signs tend to be. And there are tests, there are tests to assess.
I went through this with my in-laws, and one thing I noticed was that they would be different throughout the day. In the morning, they would get up, and after a while, they were, aware and seemingly normal. And then as the afternoon went on, the in this case, Alzheimer's became more obvious. And then later in the day, they were obviously had no capacity. And so of course, when do we take them to the doctors? During the day, because it's easier to get them in and out of the car, and easier to get them to comply with the doctor when they're functioning at their height. And so, of course, all the medical reports are going to show they're alert, because you're there at 11 o'clock or 2 o'clock in the afternoon. If ever the doctor appointment was at 5 p.m., it'd be, wow, he's really lost a lot of capacity. And so, as a real estate agent, I had that experience once. I went to somebody's house at like 11 in the afternoon, and I had a reason to call him back like at 4, and it just didn't make sense, like on the phone. And then this guy called me really upset, who's his son. He's like yelling at me as though I was trying to cheat this guy. Like, why are you upset with me? Well, didn't you see him? And I said, yeah, I saw him. He looked, normal to me. And he goes, when were you there? You just saw him, didn't you, at meeting at 4? And I said, no, actually, I was there at 11. And I said, I called him recently. He goes, oh. He goes, yeah, he's pretty cognizant in the morning, but come the afternoon, doesn't have capacity.
It's tough. It's tough because that's a very kind of common theme that we see and hear about. And what we've been told, again, from the input of judges and what we've seen, in cases, is when you don't know, the benefit of the doubt goes towards the person having capacity. I've been told once by a retired judge who was acting as our mediator, and, the medical evidence was really strongly suggesting that this person did not have capacity, but we did not have a letter from a doctor saying, look, this person's been assessed and they cannot make their medical decisions. Sometimes, in rare instances, we do have that. And those are great. But if you don't, But what that judge told me is, look, we're going to assume that if this person is incapacitated for 23 out of the 24 hours of the day, that document was executed in that 1 hour where the person was lucid. They're going to play it safe. Because what you're asking to do, and what we as attorneys oftentimes representing people are asking to do, is for a judge to basically tear up a legally valid document on its face. Something that looks fine, is signed, is notarized, or it's witnessed, whatever the case may be. It's valid
Right.
on its face. You're asking them to void it. So you better come with strong evidence, very compelling evidence to void it out.
And you're also talking about removing somebody's free will after they're gone. And I remember I'm in LA court a lot, and whenever Britney Spears had a hearing, there'd be like these big demonstrations, a big news event, and people were very passionate about it, and on both sides. And I remember discussing with somebody, and I said, it should be a very high bar to take away your rights. I don't know about her case, and I don't know the facts at all, but I'm just saying philosophically, for somebody to lose their right to make decisions in their life, that's the ultimate right. At some point, you're no longer a human being. You're just like you're like a horse with a leash around your mouth or bit in your mouth, and you're going to do what people tell you to do. It should be a high bar to take away people's rights. Not saying on any particular case, but it's right that judges are hesitant. I think it's a healthy thing. There's a little bit of judicial modesty in that regard.
Yeah, I tend to agree with you, even though sometimes it works against me. But again, it's the cases that come to us, we vet them. So not that we take anything that comes through the door. The ones where it's you really kind of raise your eyebrows as to whether or not there's a case there, we're not going to take that. But something's gotta certainly look wrong, and with each passing case that we process and handle and conclude, our ability to spot the potential problems become sharper. Yeah. So we really try to fine tune our intake process and vet the cases and our clients, because not every client is honest and forthcoming. Some of these people see a potential payday and they're opportunists. So we have to be very careful about that. The opportunity could swing both ways on these cases. So
I can tell you there's a pattern to that attorney who'll take any case, which is they get the case like a week before the hearing, and they're substituting in. They know there's been an attorney or two before them. They tend to be older, smaller firm, maybe a one-man shop. And, I see that over and over. I've learned how to go in the Cal bar and check and vet it that way. Because for me as a real estate agent, I want to know, is this claim going to be legitimate, or is it just somebody trying to throw something against the wall? I had a case recently where we had a decedent, and the bad sister got a deed notarized in Mexico, transferring everything to her. But the guy had died like 12 years ago, and the deed was dated like 5 years after he died. Well, obviously it wasn't him, right? Then it turns out she deeded it into a trust, and I knew the attorney who did the trust, and I called him up and said, look, I'm not here to argue the case with you, but when you do a trust, do you go back and check, no, they give us the deed, say this is my property, and they transfer it. I said, oh, FYI, you might want to look at this one. Here's a death cert. Here's the date of the deed. And he looked at it, appreciated it, because you're not going to vet it the same way on a trust document as you are in litigation. But you have to, I think, see, who is this person, where are they coming from? If you're getting a litigation, you spend the kind of time on a case.
Yeah, absolutely. I mean, we're in one of the rare areas of law where I depose quite a few attorneys. So that's, usually the first person whose deposition I take is the attorney that prepared the document, if there is an attorney that prepared the document. And you'd be surprised how flat-footed some of these attorneys are caught, when you really start to scrutinize their practices. It's like, what do you mean you didn't meet? What do you did this all over the phone? How did you verify that the person you were speaking to was who they claimed to be? Or you just communicated via email? Again, same problem. Like, how do you verify the person on the other side is who they claim to be? So it's dangerous for attorneys, and it both kind of shocks and dismays me sometimes how easily attorneys kind of almost assist with this type of stuff, and only to later regret it, because now they're being deposed by somebody like me, and their whole kind of practice is being scrutinized and picked apart. I don't want to do it. I don't take any kind of pleasure from it, but then again, it's my job. And the other thing that I want to kind of touch on is our firm, Trust Law Partners, we really have to believe in your case to take it. And the reason I even bring that up is because we're one of the very few law firms, especially of our size, that take these types of matters on contingency. Clients come to us from all walks of life, some penniless on the street. I've had homeless clients before who come to us and they're like, something, I'm no angel, but something stinks to high heaven here. I'm not being given, a copy of the trust, or I'm not being given my inheritance, or I'm not being given XYZ. Can you help me? And that person or those types of people would be, completely out of luck, and they're underserved and unserved most times. So as long as they have a viable claim and they appear credible, and we do our research before we take cases on, so they might, we were provided a set of facts and then we investigate it as best we can. We help these people. So we're standing shoulder to shoulder with our clients going into battle. It's not, we're not mercenaries in that regard, because it's not like, oh, I don't care what the outcome is, I'm going to get paid either way. No, that's not the case with us. And we take pride in that. We have hourly clients. Those people are usually more affluent, and they could afford the high rates that come along with litigating in kind of a specialized area or like a niche. But some people, it just makes sense to do it that way. Other people don't want the risk, don't want to have to pull a second mortgage on their homes to try to get their rightful inheritance.
I interviewed a prominent litigator in Orange County who had a huge victory. I want to say it was $50 million or so. The clients came to him originally paying by the hour. They had the victim was now destitute, but she had a sister who was able to, I think finance a couple $100,000, which they thought was plenty. And as it went on and things dragged on, and the defendant, got more and more aggressive defending himself, it cost more and more. And fortunately, in their case, the attorney was able to flip it to a kind of a combined of cash up front and then contingency going forward, and saw it to the end and won, and everybody got money and it all worked out, thank God. But that being able to do it on contingency, I think, is an important piece, because if you're not able to, and they run out of money, then you're stuck, and you invest all that money into a process, and another attorney is not likely to pick it up at that point. You're really just stuck.
Yeah. So. And you'd be surprised the type of people who are interested and opt for a contingency. We've had, clients or potential clients come to us, and their names everybody in the United States would recognize. Right. And we're talking about, $1 billion cases. And they're like, well, we spend millions and millions litigating this case for over a decade. That was a very complicated case. But we're tired of it. We're looking to switch up, and we want somebody who could do it hybrid, as you suggested, where it's part contingency, part hourly, or contingency altogether. And it's a relief to most people to be offered that option of contingency, because, again, they don't have to worry about how they're, taking food off the table if a bill becomes exorbitant, so, yeah.
It's a big stress. It's a big stress for people, and to have that option is important. So you mentioned 3 factors, the third being financial elder abuse. Describe what financial elder abuse looks like and what's a common fact pattern there.
It's very similar to undue influence. So, if you have one, usually you're going to have the other. The benefit of financial elder abuse, and the reason we like to plead it where the facts support it, of course, is it comes with a civil jury trial. Financial elder abuse is a civil cause of action, a claim that, well, I won't reveal all my tricks, but it's something you could allege. But jury trials have a way of applying pressure or leverage, because in probate court, you do not have a constitutional right to a jury trial. Your case is being heard in front of a single judge. Whereas financial elder abuse, you have the benefit of a jury. Juries, it could help you or it could hurt. I mean, it depends on which side of the case you're on or how your client is perceived. But if utilized properly, your client is going to be sympathetic, and the bad guy is going to look like a bad guy. Right. And juries like to punish. And when it comes to financial elder abuse, it comes with other benefits, such as being able to seek punitive damages, punishment damages. Aside from what's been taken, and aside from recovering what has been stolen, you also get the big slap on the wrist. Which a jury could assess against and levy against a wrongdoer. Fact patterns, I mean, there's all kinds. I'm happy to go through.
Well, and when people hear about outrageous punitive damages, they need to understand the point of it is to be so punitive that not just that person, but other people stop that activity, right? It's meant to be such a deterrent that the bad guys, not just the one on trial, will stop. And that's really the message they're trying to send through the punitive damages, I think.
That's right. Punitive damages are meant to be a deterrent as well.
So I'm sorry, I interrupted you. What are the most common or one or two fact patterns you've seen on financial elder abuse? I know, I have another podcast on reverse mortgages. There was a time when they would do a reverse mortgage, take all the equity out, invest it in some overpriced annuity, churn the assets over 3 or 4 times, and end up taking all the person's money, and that changed because of so many lawsuits on the reverse mortgage. The product actually changed. What are common financial elder abuses that you see? Mortgages or taking stocks and stock portfolios and churning them over? What are the common fact patterns?
Oftentimes we see financial elder abuse present itself when you have somebody, the bad guy, getting involved with the decedent prior to their death, and usually siphoning money out, liquidating investments, just stealing cash outright, stealing, I've seen anything from gold bars being stolen from somebody, to pieces of real estate being stolen, just taken. That's how we see it. It could be from a family member. It could be from a friend. It could be from a business partner. It could be a caretaker. Caretaker is a really bad one. Caretaker, there is a caretaker statute, that's Probate Code 21380, that says, if it's given to a caretaker or somebody who helped create the trust, there's a presumption that the document is a product of undue influence, and it's automatically void, that gift to that caretaker, unless they do, they can take a step and obtain what's called a certificate of independent review. So the person who, executed the trust sits down with another independent attorney who asks them a host of questions and then signs a document that says, I've spoken to this person and you're good to go. But I've had a felon caretaker who was in the real estate business. She was in mortgages and was, popped for mortgage fraud on a federal level. And she had a restitution order that I came to find out later. So this all came to light way into the case. But what was presented to me was, there's an elderly husband and wife. Wife passes away. The elderly husband, keeps on the caretaker that were hired for the both of them when they were both, still alive. And all of a sudden, her whole family moves into the house. The husband's the gardener. The son's, does maintenance around the house. And, old man buys a car for the caretaker. That's how it starts. And then, she's very nice to him. And he, because he's, of advanced age and his cognitive abilities are not as sharp as they used to be, allegedly, because he was gone by the time I got to the case, falls in love with the caretaker.
Sure.
Yeah. And then they go on a cruise together, but he doesn't know that her family is also tagging along on a cruise in a separate room. Nothing goes on physically or romantically between them, but, this person lives with that hope. And he's paying for all of it, and all of a sudden his house, the deed gets transferred or left to the caretaker in the trust.
Imagine that.
Responsible for, the kids are completely out of the picture now from the trust standpoint. And, of course, this person, this decedent had no idea that he was dealing with a snake, a convicted felon who had a restitution order of over $800,000 by the federal government. That was an interesting case because despite uncovering all this evidence, she refused to cave. We went to one mediation and she was defiant. She was defiant. And it just, shocking really because, she's facing down a pretty brutal thrashing if we go to trial. And they agreed to go to another mediation down the road several months after the fact. But before the second mediation, I reached out to the Department of Justice and I poked around. I'm like, there's a restitution order here. How does it affect, if this person were to take under this trust, would you guys just vacuum it all up? He's like, absolutely, to satisfy the judgment. And so we got the Department of Justice involved. I got to meet a couple of really awesome, U.S. attorneys. And she finally came to her senses and relented. Sometimes you need to think outside the box to litigate these cases. And we were fortunate enough to restore our client's inheritance.
Hoping they're coming for you there, Greg. I'm not sure. Hear the sirens in the background. Well, look, I kept a little bit longer than we scheduled. Obviously, this is a very broad area. I imagine no two cases are the same. I appreciate kind of giving us a great overview on probate litigation. If somebody has a case that they want to talk to you about, particularly an attorney, and I say as real estate agents, we want to vet the case before we bring it to somebody, make sure we have an idea of what's involved and what the issues are. But if somebody's interested, what's the best way to reach you? I know we have your website, trustlawpartners.com is the website, and then there's a phone number. Is that the best way to reach you to talk about a case?
It is. We also have for a submission, you could submit a request for a consultation. We're probably one of the only firms that has an actual attorney, like a licensed practicing attorney who does the intake process. Usually you're talking to a secretary or sometimes even just, some call center somewhere that just takes basic information. Not our firm. You're talking to an attorney from the jump. Yes. Or at the very minimum, the first consultation will certainly be with an attorney. But that is how you can contact us by email, by phone, however our clients please or potential clients please. They're welcome to reach out. They can also reach out to me directly. I'm happy to talk to anybody. My email is gaslanian@trustlawpartners.com, and I'm happy to answer any questions. I'm not stingy with my time.
Fantastic. Well, we'll put that in the show notes for later, as well as up on top, the contact information. And I really appreciate your time here. And again, and just to wrap up, I guess, really serving all of California primarily.
That's absolutely right. Yeah.
Yeah. All of California. And then what I always tell people is the laws are the same throughout the state. The procedures are different in different counties and cities, obviously different courts, but the laws are the same throughout the state. And Trust Law Partners is a big enough firm that has offices throughout, as you said, through all the nice cities in California. So again, Greg, thank you so much for your time today. I really appreciate you sharing with us, and we'll look forward to talking again soon.
My pleasure, Bill. Thank you for having me.
Thank you. And for everybody else, this is Probate Weekly. We do this every week. We talk to leading attorneys, also vendors in the business to help us learn how to be more effective dealing with our customers and building our business, whether you're an attorney, a real estate agent, or a vendor in the business, probateweekly.com. We continue the conversation on Facebook. The group is Probate Weekly as well. For your comments there, questions, if you're looking for referrals, it's a great place to do that. As always, I'm Bill Gross, at Bill Gross Probate on social media, and make today your best day ever. Thank you so much. And Greg's gone. Very good.